Hi, my name is Paige Carey. I'm a labor and employment associate with the firm Schoeneck King in the New York City office. And I wanted to give a brief overview of one topic that we touched on at this week's Business in 2024 presentation on Tuesday at 12. So during this presentation, discussed the Third Circuit's recent opinion in the case Johnson versus the NCAA. And as a brief overview of a couple of different points that I touched on, the Third Circuit, through a panel of 3 judges, affirmed the district court's denial of NCAA and member schools' motion to dismiss a case that was brought by 6 student athletes against the NCAA, as well as their member institutions. And in this case, the student athletes claimed that the defendants had violated the FLSA by not paying them at least minimum wage for their work as members of teams. Ultimately, at the lower court level, this case was adjudicated by the Eastern District of Pennsylvania, and the NCAA asserted a motion to dismiss the allegation, which the court denied. In the Third Circuit panel of 3 judges, this panel affirmed this denial of the NCAA and member schools' motion to dismiss, finding that college athletes cannot be barred as a matter of law from asserting FLSA claims simply by the virtue of amateurism, which the NCAA has traditionally asserted as a defense mechanism in courts. Ultimately, however, the panel of Third Circuit judges vacated and remanded the district court's decision for application of a different test than was previously applied by the trial court in order to assess the athlete's employment status. And the test that the Third Circuit created is based on NLRA precedents and asks a couple of questions, those being: first, does the individual perform services for another party? Second, is the service necessary and primarily for the other party's benefit? Third, is the individual under that party's control or right of control? And then lastly, is the service done in return for express or implied compensation or in-kind benefits? Going forward, we're likely to have several years until the answer to the question of whether student athletes can be considered employees under the FLSA is answered. And this issue is likely to ultimately go up to the US Supreme Court because the stakes here are so high. So we intend on keeping track of this issue and keeping everyone posted as developments in this area occur. And we hope that you will join us next week at noon for our Business in 2024 presentation on Tuesday at 12. Thank you.